Great. Thank you for having me. I'm glad to be back and happy to answer everyone's questions. Let me go ahead and share my screen and we'll just kind of jump right in. Let's see. Been doing this for so long and still not sure if everyone can see my screen when I share it. So
yes,
that's always fun.
You're good.
Okay, perfect. So like Nicole said, I'm Madison. I'm an attorney in California. We handle exclusively estate planning. So we do, wills, trusts, power of attorney, healthcare directives, all the fun stuff that no one wants to talk about or think about. So we're going to kind of go through the top 6 or so questions that I've put together to try and give a general idea. And then I'm happy to answer any personalized questions you guys might have. So the first question is, what happens if I do nothing? What if I don't have a will? What if I don't have, a trust? What if I don't have any documents in place? So in terms of if you don't have a will or a trust, the laws, whichever laws of the state that you live in, because all 50 states have their own laws, they have a process. It's called if you die intestate, and they have a process for where everything that you own goes after you pass away. So if you don't have anything set up, the law has it set up for you. Typically, it would go to your children. If you don't have children, it would go to your parents or siblings or nieces and nephews. There's usually an order set up. I highly doubt that varies from state to state. And I'll show you on the next, or on this slide. So it kind of shows, if you ever looked at a family tree, go out to that second cousin twice removed or something like that. If that's the closest next of kin you have, that's where the law says it would go. Probate itself is typically just the court process that your family would have to go through in order to transfer your assets to your beneficiaries or your next of kin. It's usually just a court supervised process to make sure that no one's misappropriating any funds or assets for themselves. If you don't pass away but are incapacitated, you have dementia, anything of that nature where you're no longer able to manage your finances or make your own healthcare decisions, the court also has a process for that. If you don't have a healthcare directive or power of attorney in place, somebody can apply for a guardianship or a conservatorship. Most states it's called a guardianship. California likes to be different and differentiate that a guardianship is for someone under 18 and a conservatorship would be for somebody over 18. But that would be the procedure. It's like a probate, it's court supervised, and it's basically a court supervised guardian over the person to be able to make decisions and handle your finances. So there is absolutely something in place by the law if you don't have any documents in place. They may not be what you want, but there is something there. Next question. Oh, well, I kind of just answered this. What happens if I can no longer manage my finances? So this is where having a power of attorney would come into play, because then you would name somebody who can handle your finances for you if you're incapacitated. Yes, there's a court procedure in place if you don't have a power of attorney, but that's costly. And a lot of people don't have, that the money is supposed to be there for your care and your enjoyment, when you're retired, not to be paying the court or an attorney to file for a guardianship for you. So a simple power of attorney can cut off the need for court. All right, what do I do if I don't have any close friends or family that I want to name as my power of attorney or my trustee, my executor, my healthcare agent, all of the things? If you don't have someone that you trust or that you would want to do that for you, there are a few options that you might have. One is you can name a bank or a professional trustee. In California, we call them licensed professional fiduciaries. Attorneys can usually do it. In California, attorneys are automatically fiduciaries once they pass the bar exam. Every state probably has their own, and most states, an attorney can do it for you. So if you absolutely need to name somebody, you can always name an attorney. We get a lot of people who like to use professional trustees just because even though they might have kids, they don't want to put that on their kids to handle things after they pass away. So those are options for you. A lot of times the people who will be your professional trustee will also be your power of attorney if you're incapacitated. Obviously, you would want to make sure that you get along with that person because they're the one that's going to come help you pay your bills or pay them for you, give you money when you need it, things of that nature. So you want to make sure you're compatible. Just from my own perspective, that's not a legal rule, but you would want to get along with the person that's taking care of you, right? And then healthcare agent, most people who handle finances will not also be your healthcare agent, but one way you can prevent from needing somebody to be your healthcare agent is to be your own. So having a good power of attorney for healthcare or a good living will, or in California, it'd be a good advanced healthcare directive. So even if you don't name somebody, you have your own wishes listed so that the hospital will be able to follow your wishes if you're unable to participate in your own healthcare. And then another document is that hot pink document on the screen, and that is called a POLST, or Physician's Orders for Life-Sustaining Treatment. And that is something you fill out with your doctor. It is, in simple terms, it's a do not resuscitate, but it is more specific than that. So you can have, a little bit more direction to your doctors regarding that. And that is something that all hospitals, all EMTs, paramedics, police, they all look for that if they come to your home. So typically people leave it on their fridge, but that's something that they're supposed to take a look for before, administering any CPR or life-sustaining treatment. So that's one way that you can make the decision and communicate it with your doctors before you lose capacity, and without having someone who can speak for you. Okay, what is the difference between a trust and a will? And do I need one or do I need both? This is going to be a little bit state specific because every state is a little bit different. In all the states, a will, typically just a will by itself, typically requires a probate, which is that court oversight. Now, in California, that is horrific because it takes almost a year to get that's if everything goes smoothly, it takes a year to get a probate taken care of. So in some states, they might have a much more streamlined probate process for certain things, depending on usually what the assets are. So by itself, a will would require probate. There's usually a statutory fee that goes to the attorney, not an hourly rate. It's just a statutory. In California, it's like 4% of the first 100,000 and so forth. It just goes on. And everything goes directly to where the will says it goes. With a living trust, that avoids probate. So essentially, if you pass away owning property, a deceased person is not allowed to own property. So you can't transfer that to somebody else. So say you own your home, and when you pass away, you're on title, you can't sign that deed over to your kids. So if it's in a living trust, it's already in the title of the trust on the deed. So whoever you've named as the successor in the trust can turn around and sign a deed over to your children. Whereas if it's in a will, it's just your name, the judge has to sign off on the person that can sign the deed. So it's complicated, but it really depends on what assets you have and how you want your belongings to be distributed. If you don't have any complicated assets, you can put a beneficiary on your accounts and call it a day. Where a trust would come in handy is if you have someone in your family who is special needs. They receive public benefits like Medi-Cal or SSI. You don't want to leave them any money outright because they could lose their benefit. But if you have it in a trust for them, that can help preserve their benefit and they still get the benefit of receiving money. There's a lot of specific details that it depends on. How often do I need to think about my estate plan? So if you have an estate plan, typically when you would need to update it, what I see in my practice is the big update is when people who set it up when they have kids, now the kids are grown and established, that's a good time to update your documents. Usually, they have it all written so that it's to be held in trust for their children until after they graduate. And they have like their siblings as their trustees and executors. Eventually, the kids are old enough that they can be the trustees and executors and not have their funds held in trust. So we like to say that's the big one. When the kids are established, if you get a divorce, if someone in your that you name in your documents passes away, it's always good to check in if you have big asset changes, purchases or sale of property. May not mean you need to update anything. And then any type of falling out with your friends that you might have named in your documents is a good time to check in as well. It's always good to check in and see if you need to make a change. Most of the time you may not need to actually make a change, but it's always good to double check with your attorney. Okay. Everything is held joint between me and my spouse. Do I need to do anything when my spouse dies, even though it all goes to me? And that answer is yes. So if you don't have an estate plan, which I would say a lot of people don't have an estate plan when they're married, because everything is held in joint tenancy and it just passes from one spouse to another. You don't have to worry about taxes passing between spouses, things of that nature. But what people don't realize, I think, is that usually all those accounts are only on one spouse's social security number. So it's always good to go update all of those accounts, make sure it's reporting on your social security number, making sure that you've updated beneficiary designations. Just because your spouse left you their IRA doesn't mean that the beneficiary designation goes with it when you rolled the IRA into your own name. So all of those things need to be updated to make sure you have the correct beneficiary designations as well. And in terms of property, if you own any property, you would want to make sure that you have that set up to go to somebody after you pass away. So that's always something that you would need to do when a spouse passes away. You always got to do those last taxes and make sure everything's in your name now. Okay, I know that the big topic is what your questions are. So please tell me you have some questions rolled into there.
All right, let's see what we got going on here. Let's go into okay, so questions. Does anybody want to raise their hand and ask a question? If they have a question for Madison, yep, Johnny, go ahead.
Okay, I've got a trust, but I have some property in another state, and I'm just really not sure how to get the lawyer in my state put my home and everything in there when he established it. But I know he told me to get the other property into, I'm not sure who to contact to do that.
Okay, it's the same for us, right? Like I'm in California, I can't put an Arizona property in my California trust, not because you can't do it, just because I don't know, I'm not familiar with Arizona deeds. There is a company called UDeeds, UDEEDS. I'll put it in the chat.
Okay, thank you.
And they do deeds all over the country, and they're just a third-party vendor that can help you process that.
That's great information. Thank you.
You're welcome.
All right, and Rose, go ahead.
My sister and brother live in another state.
Mm-hmm.
Their health precludes them from moving or driving, traveling, anything like that. I'm the only one left here. I am curious as to, I have my husband's cousin who I trust with my life, literally. He is here. I'm wondering if I can set up the paperwork so that my sister can handle it, but he can do it from here. How do I do that?
What state are you in?
Washington State.
Okay. You can set them up as co-trustees, and the trust can be worded such that the trustees can act separately.
Okay, I have to set up a trust.
Well,
there's nothing except what will be left in the bank account and what's in the house.
Okay.
I rent an apartment. I don't have a house.
Okay. So you would like your sister to make decisions, but someone else to be able to sign for her. Is that what you mean?
Right. Ronnie lives here, and Debbie and my brother John live in Idaho, but their health precludes them from any travel. In fact, I'll probably outlive them, but I've got to have something set up. I know that. And
do you have a will or anything like that?
That's something I'm going to have to do. And do I need to get an attorney, or can I just write it? Or
you can hand write it and sign it, or you can Google and see if Washington State has a statutory will. Some states have statutory wills. It's like a form that you can fill out.
Okay.
Yeah. You can have your cousin handle everything and then leave it to your brother and sister father-in-law.
Oh,
I mean, you can have him just kind of wrap up your estate, and then you don't, just because you name them as your executor doesn't mean you have to leave them everything.
well, they're the
They
only
can get,
ones
they'll
left.
get, well, they'll get paid for it, but you don't have to like, leave them everything. So,
Right, okay, because Ronnie's gonna pretty much have to handle it all from here. And like I said, I trust him with my life, so
yeah,
no problems with that. All right, well, thank you very much.
you're welcome.
And I have one other question for
Yeah.
you. My funeral expenses are all paid except my cremation. And when I get my income tax refund this time, I'm going to pay my cremation fees.
Mhm.
All the open, closing, the niche, everything's paid. I have all the paperwork on it. Do I have to send a copy to my sister and brother? And then have Ronnie keep the originals here because he's the one that's gonna handle it.
Yeah, you could do that. That sounds like a good idea.
Okay.
We usually
because-
say that that's up to you. That's your comfort level in terms of,
Well, I just don't want anybody saying, well, I never received anything.
yeah.
You know, little brothers and little sisters. And that's
Mhm.
what they are. They're younger than me.
Yeah, I think that's a good idea. I think just in this topic alone, it is much better to talk to everybody about everything than for there to be surprises later.
Well,
Sometimes surprises breed contention, and nobody wants to leave that.
I've been talking to my sister. My brother just recently lost his wife. So he's not been in the mood to talk to anybody,
Sure.
which I understand. So I just want to know about that. And I was wondering, on my bank account, do I need to have Ronnie put on it so that he can access it?
If you have Ronnie put on your bank account and it's like as a joint owner with you, then that account will be his after you pass away. It doesn't go to anybody else.
All $28.50
Uh-huh.
at the end of the month.
Yeah. So if that's okay with you, you can do that. Otherwise, you can name a beneficiary on it, like a POD, pay on death, or a transfer on death, and that designates where it goes after you pass away. Sometimes you can have him added as a signer without being an owner. So that would be good if you're incapacitated, and then after you pass, it would go to the beneficiary that you choose. It just kind of depends on how the bank sets it up.
Okay, well, there's not anything.
Sometimes each bank has their own power of attorney form you can fill out at the bank too.
Okay, thank you very much, Madison. I appreciate that.
You're welcome.
Okay, so let's go. Faye, I see you, Mariana, and then we have a few. Well, quickly here, I document again for the physician, the pink one. What is that called? Johnny wants to know.
It's called a Physician's Orders for Life-Sustaining Treatment, or POLST, POLST for short.
We can put that in the image.
I'm doing that right now.
Okay, great. All right, so that is that one, and then dual power of attorney advantages versus disadvantages.
I don't know what they mean by dual power of attorney. Jean, do you want to elaborate?
Jean, if you want to unmute and elaborate on that one. Does that mean like a sister and a brother, or two sisters, or two brothers? Hang on, Jean, if you were there. Is Jean here? Yeah, Jean, if you want to unmute, hold on. Let's see if Jean can unmute. All right, well, we can get back to that. Yeah, I mean, I'm thinking she's talking about when you have like a sister.
Two agents, co-agents.
Co-agents, and then basically what happens, like if you live in two different states, that I know in Florida it becomes an issue if you have one in a different state,
Yeah.
then you cannot make a decision for the person if you have to have both people, if they're both the dual, correct?
Yes, a lot of times it's going to depend specifically on your assets and what they need to access. But typically, if you have joint powers of attorney, we call them agents, then it can be logistically a nightmare. And if they don't agree on something in your best interest, The only way to solve that is to go to court. And that defeats the purpose of having the power of attorney in the first place. So we don't typically advise it. I mean, if you have two kids and they're twins and they get along great and that's what, and they're both local to you, more power to you. But we don't typically advise it. We don't stop our clients from doing it, but we don't advise it. We at least explain the pitfalls of what could happen.
Yeah.
The good thing is if you name two, one can always resign if they run into that logistical issue. So it's not like if you name two people to be co-agents and then you become incapacitated and then they can't do something, they're not stuck. So somebody can always resign and leave it to that one person to handle everything.
Yeah. Okay. All right. And then Faye, go ahead.
Hi. I made a will around 20 years ago. You think I should update it?
Has anything changed in the last 20 years?
No, my two boys are alive. My two grandkids are alive, and nothing really.
Yeah, just everything to your two children equally, and they're your executors?
No. Yeah, you have an executor, yeah.
Yeah. Yeah, as long as it reads the way you'd like it, there's nothing wrong with that.
Okay. Thank you very much.
Yeah, you're welcome.
Okay. And Mariana, go ahead if you want to unmute.
Yeah. What's involved in the trust? And what are we looking at for an attorney fee?
Yeah, so a trust involves typically for us, I can't speak for every attorney, but we look at what you have and what your goals are, and whether a trust is the right way to affect that. If it is, which in California, in this case, most places, if you own a house, that's probably the best thing to do. We just ask you a bunch of questions. You have to decide who you want to be your trustees, who you want to divide your estate up amongst, any specific gifts that you want to make, things like that. Just determine, who gets to determine if you're incapacitated, a few questions like that. And then we write it, we draft it. Most attorneys use a software system that helps write it. It's full of nice legal jargon for things that probably will never apply to you, but we put it in there so we don't commit malpractice. And then we have you sign it. The big thing on your end, or the person signing the trust end, is the retitling of your assets. So typically the attorney would help you title your house in the name of the trust, but it would be on you to go to the bank or talk to a financial advisor to retitle the bank accounts, brokerage accounts, any life insurance in the name of the trust. Retirement accounts don't typically go in a trust unless you have a complicated distribution, or you have someone with special needs where you don't want that to go to them outright. And then the cost really depends. I mean, you can do the do-it-yourself route with, and it's like, who does like Nolo and who does the other ones that you can, like LegalZoom. Those will say attorney reviewed documents. That just means the documents are written legally sound. It does not mean that they're reviewed by attorney as to your specific situation. So just throw that out there. If you have any type of complicated situation, that's probably not the best bet, but those go from a few $100s, and typically it goes up to $4,000 or $5,000. It kind of depends on the complexity of it.
What is that? Legal what?
LegalZoom.
Okay.
Yeah, LegalZoom and Nolo, Nolo. At least we have those in California. I don't know.
That's
they're internet based. So
Yeah, yeah.
I'm looking at property mostly. That's what I'm thinking about.
Yeah. Typically you don't want to be drafting deeds yourself. You don't necessarily need an attorney to do a deed unless you're in maybe Massachusetts, Commonwealth. Sometimes they require attorneys to be involved. But you can have a title company or like that UDeed service to help prepare deeds for you. That's usually the trickiest part, because if the deed's not right, it may not be valid. And then then it makes everything a moot point.
Okay. All right. Thank you.
You're welcome.
All right, Sherry, go ahead if you want to unmute. Hang on. Go ahead.
Thank you. I was just trying to write it out in chat and it was getting really long. I have two questions actually. I need something that would actually walk me through step by step, and that gives me all the ands, ifs, and buts, what happens, and under all circumstances. That in the medical advisory, when do you pull the plug or when do you do this or that, and also with a trust passing on. Like I have 4 siblings, and I would like to have it distributed between the 4. And but I have a sister that is on public assistance, and so her portion would need to be handled something differently, and there would need to be somebody else that would be responsible for handling her account and determining how the money should be distributed to her, how often and how much, and then handle if there's any, financial decisions that need to be made as far as how the money is handled itself. Is there a document that will walk me through all that?
Okay, so for your power of attorney, I think that, do you have Kaiser or Sutter for healthcare, for your Medicare?
I have Medicare and I have United Health.
United, okay. I was going to say Kaiser sometimes, and I don't know how big Kaiser is everywhere else, but they were born here, so it's big here. But Kaiser themselves has an advanced health predictor that's a whole booklet, and they ask a lot of questions. And so that's something that you could probably get your hands on. You could probably Google one that just is a whole booklet that you can get your hands on. There's also a book called 5 Wishes, I think, and it's, I hear the presentation from the hospice companies, but that's good for end of life. And then the pulse itself, you actually fill out with your doctor. You can certainly fill out a healthcare directive with your doctor. So if you're not sure, like logistics, like I know for us, the big thing, right, is that for most of the healthcare directives in California, it starts off with 2 choices, A or B, prolong life or do not prolong life. And then it talks about artificial nutrition, hydration, and ventilation. And when COVID hit, everyone's like, well, I want a ventilator, you want, because that was one of the only treatments. So that was a big thing, but it's sometimes difficult to understand and read it, that it says that's only when you say you don't want a ventilator, that's only in the event that there is no hope for recovery. So what they mean is that you're not going to be on, life assistance life support for a long time. Whereas with COVID, it's actually a treatment. So sometimes talking to a doctor or a nurse and having them explain to you how it actually works is the easiest thing to do. I don't know if there's a book or anything like that other than Google, other than an attorney, obviously, that could help walk you through each question on a healthcare directive. In regards to your sibling that's on public benefits, if a trust is drafted, there's 2 things. One is that she could have her own trust. Somebody could create what's called a third-party special needs trust for her. And then if everybody wants to leave her money, they could all leave it to that trust. And then you have one thing. The other thing is that, like for us, when we draft a revocable trust, we have a provision in there, like a backup provision that says, if somebody that is a beneficiary of this trust is special needs or on public benefits, then the money can be held in a trust for them. The big thing with people on public benefits is that, like you said, exactly like you said, they can't be their own trustee, and the money cannot go to them directly. So they cannot write her a check. They can pay for her to go on a trip. They could buy her a car. They could pay for any, things like that, but they can't give her the money directly. It kind of depends on what her benefits are specifically, but that's the gist of it, is that it has to be written that way, that the trustee has absolute discretion. She can't compel the trustee to do anything. That's what makes it unavailable in terms of the benefits.
Can you put the titles of the stuff that you just said in chat?
Yeah. Can I just?
I can't write stuff down fast enough, so I like to copy the you know,
Yeah.
save the chat and print it
Yeah.
out later.
Yeah, let's see.
Okay, so I know. Okay, so we're gonna add that in there for you, and then if we could,
Yeah, just like the 3 wishes and,
yeah,
Okay.
five wishes in the author, we can find that,
yeah.
and, yeah. Okay, so that, yeah, that was Kaiser, and Kaiser is mostly for the West Coast, right, Madison? Because I know.
Well,
Bruce-
it started in Oakland,
Bruce has
so
it,
it's a
yeah.
big thing out here. I do know they have it in other states, but like they don't have it in Southern California. It's not common in Southern California. It's not as common as it is in Northern California, but yeah, I imagine you can find one. You could just kind of Google it. But if you Google Kaisers, you can find one that looks like that. You can still use Kaisers even if you don't have Kaiser. It's still a valid healthcare directive. But that's something that you could take a look at and see if that's helpful to you. You know, it asks like, what does a good day to you look like? You know, what does a bad day to you look like? Things like that. Like it's a little bit more, has more feelings involved is what I would say than maybe a statutory healthcare directive that says, yeah, no life support, no nutrition, no, you know, it's not as cool.
Yeah.
So
Yeah.
Let me see, public benefit. They need a special needs trust or yeah. Okay.
And we'll add the book in there as well, or the document, whatever that is.
Oh, the Pulse. Wait.
Yeah, Paige is gonna add that in the chat, so no worries about that.
Yeah, the Pulse I put in there before that.
Okay.
Their physician's orders. I see another question in the chat too.
Yeah, so that came from Frida. There was a couple of, I mean, she lives up north, but in Connecticut. But can I handwrite my will in reference to being cremated and have my ashes spread in the ocean? I'm aware that we have to request permission on the ferry to do it. Also, if and when I become seriously ill, can I also write into my wish that if I was to be brain dead or my chances of survival were minor, do not want to be alive through, kept alive through a machine. These are my wishes, and I've told my children, but they mentioned for me to write it down. How do you do that so that it's legally binding, without having, they know, but how do you say, when it comes to that moment of DNR, or maybe we can talk about DNR for a second, do not resuscitate.
Yeah, so I know I talked about the Pulse or the physician's orders for life-saving treatment, which is just like a DNR, but a DNR just says, resuscitate me, don't resuscitate me. It is black and white. If you have a heart attack and they need to restart your heart, yes or no. The Pulse is more specific in that, okay, if I have a heart attack today, or if Nicole has a heart attack today, yes, give us CPR. If we are 98 and the damage that CPR is going to do to our bodies is not worth it, then we can say no. And that's on the Pulse, you can differentiate on that. Where the DNR, it's yay or nay. There is no, it depends. There is no specific circumstances. So, we don't, with the Pulse, I tend to suggest a Pulse more because you can talk to your doctor and they can be more specific about it. So that's what I would suggest there.
So in an emergency, let me ask you this, Madam, this has come up. In an emergency situation, if you're 98 or if you're 88 or 31, how does the person rescuing you, at that moment know that you have a DNR? Because you're not wearing anything.
Yeah, so you can wear something. You can, if you feel that strongly about it, you can wear a medical alert bracelet. If you have a Pulse, it's typically on your fridge in your house. So if the paramedics come, they know to look for that.
Okay.
If you're in the hospital, it should be taped to the outside of your door.
Yep.
So there are ways. They have a duty to at least make a reasonable effort. They're not going to go look in your bookshelf or your filing cabinet to see whether or not you have that. So you kind of have to make sure that it's front and center when if somebody comes in the house. Now, if you are driving, if you're in a car accident, sometimes they make cards. You can put them in your wallet, things like that. They check that because that's where they're going to look for organ donation, right? And that stops everything if you are an organ donor, when it comes to what the paramedics are going to do or not do. So there's always ways to, it's not 100% foolproof. It's never going to be, a good Samaritan could save your life, so it's just, those are the things that, you run into if you feel that, the stronger you feel about it, the more effort you put into it with, a bracelet, a necklace. They have all kinds of cool medical stuff now, like bracelets and necklaces, as opposed to the big chunky, medical bracelets they used to have for people who were like diabetic and things like that. So they have all different ways that you can set that up now.
So something like Frida's question to just clear up. So if someone wants to, they don't want to get, all lawyers involved, things like that, but they want to write their wishes down so their children have it. It is on a piece of paper. It's there, and they're not in a crisis mode and like, I don't remember what mom said or whatever. What's the best way to do that? To write that down?
I mean, if you have documents like a living will or a healthcare directive, you can certainly include it in that. You can also just write your own paperwork. There's little forms that you can download off the internet that says this is what I want to happen when I die, and you just fill it out for them and keep it with your other important documents. It's not something that, unless you're worried about people taking each other to court over what happens with your body, you can just write it down for your kids, and that's important. And then in terms of like spreading your ashes, they would just, I always tell people, I'm not going to give you legal advice on how to spread ashes, because that's like the government and the EPA's problem. But like, I live in California, you can't spread ashes anywhere, right? Or like the big thing is, I want my ashes spread at Disney. That's not allowed. But if you want to pull a Shawshank Redemption and put a hole in your pocket and scatter some ashes through your pant legs, more power to you. That's just your own family personal preferences. I'm not going to give advice because I don't want anyone to get caught, but they can do whatever they need to do with that. I know we've done it, off a pier, things like that. I know this is recorded. Hopefully no one from the Coast Guard sees that, but people do that all the time. So don't get caught. It's fine.
All right. All right. So what is, okay, let me just go to Rose first, and then I see Sue Ellen has a question, and then Kathy wrote something in the chat. So go ahead, Rose.
Okay, I have on my driver's license the notification for donation of organs. Because I take a certain drug, I don't know if that's going to make my organs donatable. And I've had surgery on both eyes to remove cataracts, which means I have temporary implanted lenses. Do I have to let the DOL know these changes, or do I just take donation off and just leave it with information at my doctor's office or whatever? What do I do?
I don't think you need to do anything. They're going to check everything on their own. They have their list of due diligence when it comes to organ donation. They have to test your blood. They have to do all of that stuff. So they're going to look into all of that before they do anything with you. So I think you're okay. It'll just be what they can take or what they can't take. As long as you still want to donate what you can, they can do that. Because sometimes tissue is okay.
Yeah.
Sometimes, might not be a full organ.
For burn victims, yes, I know. I used to weigh 700 pounds, so they took a lot of tissue off of me, and that's where it went. So, but I just wanted to be sure so that I can get it up to date, because I'm trying to get everything put together. I don't plan to die for another 40 years, but that's beside the point.
That's a good plan.
Yeah, we want to keep you around.
Yeah.
I love Health Angel.
Yeah, and we love you too. So
I think it's important to point out that if you have organ donation on your driver's license, that is going to rule the day. You have to specifically revoke that or have it removed from your driver's license in order for that not to happen. So if you fill out a healthcare directive, like if you're in the hospital and you say no organ donation, but you still have registered with it, whatever it is, the National Organ Registry or, things like that, they will not go off of your healthcare directive or your living will. They will go off of your registration with the driver's license unless it's been specifically revoked. So just as a heads up, a lot of people change their mind later in life that they don't want to donate organs, or you feel like you can't donate organs. But you can, like I said to Rose, you can let them decide that.
I was going to say, you made a good point there.
Yeah.
Like if they can use it, some part, a little, however you said, tissue, the whole thing, you never know, could save someone else. So that's great information. So Sue Ellen asked, what is the difference between a living will and the post?
Yeah, so the living will is what you want, how you want the doctors to treat you, that your healthcare agent or your power of attorney for healthcare gets to make the decision. So if you name your daughter, your healthcare agent, and then you have this living will that helps guide her as to what your wishes are. The post itself rules no matter what anyone says. So if the post says, do not resuscitate me, and your kids are there begging the doctor to resuscitate them, the doctor's not going to do it. They're going to go off of this post that you filled out with the doctor. So it's just a hierarchy of the documents. So a post, usually people don't fill out a post until they're closer to end of life, or they have a terminal illness, or, something that they really put, they know for sure. With the living will or healthcare directive, you are telling your kids, this is what I don't want. I don't want to be in a persistent vegetative state on life support. But if the doctor says, if you do this for a month, there's an 80% chance they're going to come back with quality of life, I think that your kids would probably say yes, and so that's different. Whereas otherwise, if you're going off the pulse, then it just is what it is. They're not going to resuscitate you. So or have those life-saving treatments. So it just kind of depends on where you're at in your life, who's making decisions for you. The pulse allows you to make a decision for yourself, and the living will allows you to give directions to the people that you name to be able to make those decisions.
Okay. And where can someone find, like Frida asked, where can she find the post, or where do you get that?
So it's pulse.org. I'll put the website in there. They are very, they're state specific. There is a national organization, but they're state specific. So you can click on each different state. I don't know. And it just has the different names for them. And there's a directory of pulse programs you can go to. Most doctors' offices will have copies of them, or you can find them downloadable on the internet.
Okay.
Is there a specific state for one that you'd like? I could probably
Connecticut.
Connecticut. Let me see if I can get it. Keep going. I'll keep scrolling.
Okay. So there was a question. So with guardianship, that is a whole legal, you have to almost like sue. Yeah, it's like a lot to get guardianship if someone has Alzheimer's or someone's really not right. So that's really the route one would go when someone can't really make their decisions, but they're still here. They're still everything, but they're really not of sound mind to make decisions. But the route of getting guardianship, how long of a legal situation? Isn't that like a long stretch?
Well, they do have temporary ones that are usually done what's called ex parte, like emergency orders. So that can happen. If anyone watched that Netflix movie, I Care a Lot, it was horrible. Yes. It was a horrible example, right? Because it was about someone who was essentially named the public guardian to go in and take over and liquidate and throw everybody in a nursing home and survive off their cash. Yeah, that was that was a real life thing that happened in Las Vegas. But they don't typically, just name public guardians. So you can name who you'd want to be your power of attorney, your guardian. If you have a will or a trust or a healthcare director, anything like that, that usually names somebody as well. But by law, they have to notify all of your relatives to the second degree in California. So I presume every state, has the same notice requirements. They don't just get to do it without telling anybody. So your caregiver can't just file a guardianship and take over your life and, stick you in the back bedroom and take your stuff. So,
but that's the next rung up after power of attorney, because power of attorney, as long as someone's capable and alive, no one can make the decisions. It's like until you're incapable and unable to make a decision, if you were in, a coma or whatever, that's power of attorney means nothing while the person's alive and can talk.
Yeah. And there's two different types of power of attorney. So there's a springing power of attorney and there's an immediate power of attorney. So in an immediate power of attorney, the minute you sign it, that person can act on your behalf. But there's also what's called a springing power of attorney, which is more common. We usually see immediate power of attorneys, one, if you know you're going to need it right then and there, like I got an early Alzheimer diagnosis and I know it's coming, because just because you've been diagnosed doesn't mean you don't have capacity. so we're going to sign this, or your spouse, you want them to have immediate power of attorney. A springing power of attorney means you have to be declared incapacitated before the document takes into effect. So I could name, Susie as my agent today, but she can't use that document until she has 2 doctor's notes that say I'm incapacitated and I can no longer handle my financial affairs.
That's the immediate power of attorney.
That's the springing one.
Springing one. But the immediate one, if someone has early Alzheimer's, does that,
Yeah, if I get diagnosed and say, Nicole, I need you to be my power of attorney, I'm going to sign this today, you could go to the bank for me.
go to the bank, but you can't really make full decisions on anything because they're still really there, right? And that's when guardianship comes in.
Well, so there's 2 ways. So a power of attorney, yes, you can make decisions for them. But yes, you're right. So if you have a guardianship, not only can you make decisions just like a power of attorney, but you also take that person's right to make their own decisions away. So a guardianship removes your rights, just like everyone read about Britney Spears, right? She wasn't allowed to get pregnant, get married, none of the basic things. In fact, part of guardianship is you can take away your right to vote. They can say that they can't, vote. Now it's a little hard. I mean, you have to go through some extra steps to actually disenfranchise somebody, but they're there. So yeah, with a guardianship, you have, the ability to take that away. And that's good in the sense that sometimes we've seen people who are incapacitated or not even quite incapacitated, but they get scammed a lot. They're answering the phone and they're giving money to people. And it's like, but somebody else is already power of attorney, but it hasn't restricted their access to their own funds. And that's where conservatorship would come into play. Or I like to tell my clients, if that's a big concern, you should talk to the bank. If you've had to enable a power of attorney and you have a doctor saying someone's incapacitated, give those letters to the bank. The bank will likely shut off their access without you having to get a conservatorship. So if they have no access to funds, they can't get scammed out of their money. So I like to go through as many options as I can before we have to go through a guardianship or a conservatorship, because no one wants to do that. I mean, that is a full-on court oversight until they die. Yeah. And who wants to do an accounting? No one wants to do their own taxes or accountings, let alone do one for somebody else. So, yeah,
Absolutely. So I see Rose just had a question here. If I leave the house, I leave a folder with the directives, post, organ donations, and papers in my burying information at the end of my bed for Ronnie to get in case of a problem with my life. Is this a good idea?
And just tell him that's in the house and where to find it if anything ever happens to you. I think that's the best. That's, like I said, open communication is better than, needle in a haystack.
Do I need a POA for him?
Yeah, you can. Do you bank all at the same bank?
He does have an account with the bank that I bank at, a branch of it, but he has several different banks. He's retired and got
your accounts are all in one place.
Yeah, I only have one bank account and had it for 28 years.
Yeah, if that's all you have or that's all you're worried about, then you can fill out a POA with them. Sometimes, yeah, they'll have their own. If there's other things you're worried about, landlord, tenant, IRA, Social Security, then you could probably download a statutory power of attorney from the state.
Okay, because I do get Social Security money.
Yeah.
And I want to make sure my landlord gets paid, but if there's money in the account, he'll pay for that, I know.
Yeah.
So that'll give him time to clear out the house.
Yeah, there should be something that you can find there. I'm Googling at the same time. So if I find it, I'll put it in I'm not finding the Connecticut Pulse. In fact, in Connecticut, they call it a MOLST, MOLST, medical orders for life-saving treatment. You probably just have to ask your doctor for it.
So we just put it in the chat, MOLST, MOLST, medical.
Yeah.
Okay. And then Johnny asked if she has, I guess it's dual power of attorney for personal and medical care decisions or I'm thinking
durable.
Yeah, durable. Okay, so that is a thing. Yeah, effective on disability. So is that a springing one?
Yeah, if it's effective on an event like incapacity or disability, then yes, it's springing.
Okay.
Durable. The word durable in a power of attorney just means that if you become incapacitated later or something happens later, it doesn't stop. Like the end date is when you die or you revoke it. Not that there would be an event. Sometimes people have a power of attorney, like my husband and I have powers of attorney where we are each other's agents, and it's durable, meaning if I then later become incapacitated, the power of attorney is still good. It doesn't stop just because I'm incapacitated. Because sometimes people have powers of attorney that are very limited, and they're specific to, I'm going overseas for a month. I need my parents to be able to access my bank account in case something happens to me. So this is my power of attorney. It's only good from this time to this time. So in this case, durable means it just goes on until you stop it. And then springing would be the part where it's effective upon disability.
Okay. And Barbary, I see you have your hand up. So if you want to unmute.
Hi, I recently went to a seminar on the 5 wishes, which was something I had never heard about. Although in my line of work, I had advised a lot of people, I'm not an attorney, but I've advised a lot of people on end of life planning and all. But when they talked about the pulse, they kept saying over and over again that it was a green document. Now, I don't know, is it specific by color to the state?
It might be. It might be. I've only ever seen pink. I just know it's bright. The point is that it's bright, not so much necessarily what the color is.
Well, I'm in New Jersey and ours is green.
All right.
And the other thing I might suggest is most of us carry cell phones these days. And a very simple thing to do is just put in the contacts ICE, ICE, in case of emergency, and that's going to be the person they should call.
Yeah.
And if that's your power of attorney, they should have a copy of the power of attorney in case they're called upon and they can't get into your house or safe deposit box or wherever you keep it. In my case, my daughter's my POA. She has the original and I keep a copy.
Great. And if you have an iPhone.
Same with my will. My son has my original will, and I have a copy along with all the other papers because it's not going to do me any good if I'm dead.
And there's actually, if you have an iPhone, you can, and when you put someone's contact in, you can say add to emergency contacts. And if your phone is locked, they can access your emergency contacts without having to unlock your phone, like the paramedics.
Oh, that I did not know. See, you can teach an old dog no tricks.
That's right. Yes. So yeah, and is there something called a power of appointment, or is it just a power of attorney?
A power of appointment is something else. That is something that a lot of times you see in a trust or a will where somebody leaves you something, or you have a joint trust that gives you a power of appointment, and that means you can appoint. Typically, it's like if something is left in trust for you, like if your parents have a trust and you get a check every month from it, it might have a power of appointment where you can say, you can designate where that goes after you die, and sometimes it limits it to your children or your grandchildren, something like that. It's a little bit different.
Okay. And then Kathy had written just a message in here. In Ohio, special needs individuals can have a stable account. They can have up to $12,000 in there, but still after they die, the funds go back to the state to cover all they spent. If you don't have it, they can only have $3,000 in assets. So I can leave my special needs daughter something when I die, but she is her only child. I guess the church will be in for a landfall. So is that something that is most states, or, I mean, she's in Ohio.
Well, I think a lot of states, I don't know if all of them, have what are called ABLE accounts for people who have special needs. And they're specifically for people who are on public benefits and who are able to help manage their own finances. They have to be able to manage their own finances in order to do it. It's like giving a teenager a debit card. And my understanding, it doesn't matter what state you're in. And I think it might have been updated since the 12,000, but my understanding is you are allowed to gift up to the gift exemption. So every year you can give $16,000 to an individual without having to report it on a gift tax return. And so you can a person with an ABLE account can receive up to $16,000 in their ABLE account without losing their benefits. And then it goes up to the amount that is like whatever the maximum is for a 529, which is like 100 something. And then anything over that, it counts towards their $2,000 or $3,000 in their bank account. You don't have to live in a state to use their ABLE account. You can live in Ohio and use a Cal ABLE account. You can live in California and use a Michigan ABLE account. Every ABLE account is a little bit different and has a little bit different requirements. I do believe in order for that to apply, you have to be disabled before you turn 26. So it's specific to developmentally disabled individuals or disabilities that occur prior, like that you're born with, essentially. People who are on SSI.
Okay. And what's your thoughts on, having one of those fireproof envelopes, or, I know Rose said she left a bunch of documents by her bed, and what's your thoughts on that?
Being in California, I'm a big fan of anything fireproof. You never know.
Waterproof, could be
waterproof. Yeah, that goes hand in hand with fireproof. If the fire hose comes in, your stuff is destroyed. Anything that can be. What I'm not a fan of is safe deposit boxes.
Yeah.
So those, if somebody else does not have access or a key to that after you die, someone's going to have to open a probate to see your 50-year-old house deed. That's not worth anything. So like, it's not unless you're keeping the Hope Diamond in there, then a probate might be worth it. But, most of the time you would need to, or you can put a beneficiary on your safe deposit box, but they need to be able to access it. You need that key. So I think a lockbox is fine. The cloud is a great place. I know you have your technology thing tomorrow, right? Is that what you're saying, Nicole?
Yep.
The person that helps with that. So sometimes people will put it on a little thumb drive or a jump drive and give it to one of their kids, or you can upload it on your cloud, which is basically like a safe deposit box in the internet. You can do that. If you have an attorney at all, you can have them store it for you on their cloud, which is usually secure. Some banks are offering that. Cell phone services are offering that. Free cloud storage, things like that, or your email usually has free cloud storage. So, just if you can't do it, just find someone that can help you. It's not complicated if you have scanned. The hard part is getting the scanned copies, right? It's getting the copies in, which I just downloaded, taught me a new trick. There's Adobe makes a scan app that you can put on your phone that you can just take a picture of the document and scans it right into a PDF. So you can do that and upload it right to your email. And then as long as someone can get into your email or you send it to someone who you can share it with, it'll be saved. So I think it's important to note, other than a will, original documents are not as crucial as everybody thinks. Copies are just fine.
Okay. And I know we touched on this last time, but writing it down, like Rose, I know Rose wrote everything out, right? She wrote it out, she signed it, and that's it. And whoever, when they find that and get that, that's going to be legal, right? That would be fine.
It's called a holographic will. It's still in play. That's how they used to do it when these laws came into play in England, forever ago. So you are allowed to have a handwritten will. What you can't do is just have a typed will and then sign it. It's got to be all handwritten to be a holographic will. If you're going to type it, you get 2 witnesses to watch you sign it, and not your kids or anyone you're leaving anything to, your neighbors, someone down the hall, something like that, just to witness you sign it and put their name and address.
So you don't need a notary.
Nope.
No.
Most wills, and I don't know every 50 state, but I have not come across a state yet that requires notarization.
Okay.
They do all require 2 independent witnesses. So you could still have husband and wife down the street. You just can't have your husband or wife to sign it,
Okay, got it. All right, Barbara Waldron, go ahead.
Okay, so I have a will that was made several years ago. However, at the time I had no grandchildren. I have one grandbaby now who's only 5 years old. And I feel as though, my family is very small, so that's it. I want to leave everything to her. How does that work? If I die before she become of age, like I said, she's only 5 years old. How does that work?
Yeah. So in California, and I think this would be the same everywhere, is that even though she has legal guardians, parents, somebody would have to file for a guardianship of her estate. If you ever hear guardianship or conservatorship of the estate versus the person is medical decisions and care decisions, and estate always means money. So you would have to file a guardianship of the estate. Her parents would have to file a guardianship of the estate in order to manage that money for her benefit until she turns 18. Sometimes that means putting it into a blocked account. There's a Uniform Gift to Minors Act that's across the country that has the rules regarding those accounts, and they usually just sits there. If they want to take money out, sometimes they have to petition the court to do so. Otherwise, the alternative to get around that is through a trust or a testamentary trust. So you can write the will such that there's a trust within the will, and the trust doesn't happen unless she's going to unless the qualifier happens. So let's say I'm leaving everything to Susie. If she is under whatever age you want, 18, 21, 25, at least it has to be at least 18. If she's under 18, it's going to be held in trust for her. Her mom is going to be the trustee. That her mom can use the money to pay for Susie's health, education, maintenance, and support. And when Susie's X years old, she can withdraw all the money. So you can create a trust within a will. That is what you do. And then if she's over 18, when she inherits, you don't have to worry about it. It just goes to her. If she's under 18, then they would have to set up this separate trust after you pass away, and the money is ready to go into it.
Thank you.
Mm-hmm.
Okay. Yeah.
Well, I'm just going to add something to that because I just had it happen to 2 clients. If you name a minor as a beneficiary on your retirement accounts, your IRAs, and you're taking, typically that would mean if, let's say I left my IRA to my 15-year-old daughter, I die, she can't touch it until she's 18, right? And then she has 10 years to withdraw all the funds. However, if I'm already taking RMDs when I die, when I'm already taking my required minimum distributions, the beneficiary has to continue making required minimum distributions, even if they're under 18. And if they're under 18, they cannot, and required minimum distributions, even though they're required, you have to initiate it. And they, under 18, cannot legally initiate a bank transaction. So a guardianship would be required for any minor receiving as a beneficiary of your retirement account if RMDs are already taking place. So again, another court case that may or may not be worth it. So that might be something to just keep an eye on.
Thank you.
Mm-hmm.
Okay. Anyone else have any last questions for Madison? I know Rose was very thankful. Kathy as well. Just so much help. Answered a lot of questions for us today. I see Sherry. Go ahead. You want to unmute?
I was wondering, with what you just said, can you have that money go into a trust when it comes out?
You can, yeah. You can have your retirement account set up so that the beneficiary is a trust. There's an income tax difference. So if you leave it to somebody, they have 10 years to withdraw all the money. If you leave it to a trust, the trust has 5 years to withdraw all the money. And typically the trust would pay the taxes, and a trust is an entity, and the tax brackets are much more compressed than yours and my tax brackets. Like their brackets are like 10,000, 20,000, 30,000, where ours are like, 50, 60,000, and then another 50, 60,000. So they're just much more compressed. But in terms of control and avoiding a court nightmare, sometimes that's.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcounsel.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcounsel.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcounsel.com. Thanks again for listening. We'll see you soon.